we can't genuinely describe this as a conversation among friends or something like that, or perhaps even as an informal conversation. It seems to me that there's something different about somebody with a badge.
No, Your Honor. Respondent disagrees insofar as here, Andy Somerville wouldn't necessarily even know that Officer Al was a member of the police force.
So why did he ask? Go ahead.
He talked with him while he was in his full uniform the day before, right?
This is correct.
And as he's sitting in his office, he's got his shirt with a badge on, right?
Yes, Your Honor.
So anybody who sees that knows who they're talking to. They're talking to the cop, right?
No, Your Honor. In that during these circumstances, Andy Somerville had been significantly traumatized by the events going on around the events in his life.
Officer Royale is a police officer, right?
Yes, Your Honor, but in addition, Officer Real is a school resource officer as per page 5, footnote 7 of the record. His primary duties are more to teach classes, handle emergencies, and be an informal counselor. And it is this kind of relationship that Andy Somerville would have had with Officer Real, not Officer Real.
Speculation. What we know from Andy's own mouth is he asked, is he going to jail? Doesn't that indicate he's thinking that this is testimonial character?
No, Your Honor. As per page 6 of the record, the first paragraph, Andy Somerville first states that he's asking about the arrest of his stepfather, Bobby Bronner, and then asks about that arrest if he will be going to jail. The statement about whether he's going to jail was not in conjunction with his statements about the possession of child pornography, and thus they do not connect.
Well, but obviously it's somewhat related to the child porn, right? That's why he got arrested.
No, Your Honor, that was not why Bobby Bronner had been arrested in the first place.
Whether it was connected or not, he's asking him because he's a police officer and he thinks he knows the answer to whether or not he's going to jail. So regardless of the reason, if you're asking a police officer, you could say, is he going to jail?
Yes, Your Honor. And even if Your Honors find that Officer Andy Somerville viewed Officer Real as a member of the police officer, it still has to be determined whether Officer Real was acting as a member of the police force.
But counsel, doesn't that just allow police to use that theory to evade the testimonial restrictions of the Sixth Amendment, where they just say, "Oh no, don't worry, he wasn't talking to me, about past events or an emergency, but let me get this in at court," and you can't do anything about it.
Well, no, Your Honor. In that officers, when pursuing purposes for officer duties, have to make statements and question individuals. Here, Officer Real didn't exhibit any kinds of signs that he was interviewing Andy Somerville as police purposes, nor did his later actions evidence that he was acting as a police officer.
Well, but to be clear, he was on the clock, right? He wasn't off duty.
Yes, Your Honor, Officer Real was on the clock at this time, but his primary job as a school resource officer was not to investigate criminal events. It was rather to be an informal counselor and teach and settle emergencies on the campus.
So if we create this class of partial police officers, what prevents them from just always claiming, no, that wasn't testimonial, and by the way, I can get into evidence and you can't cross-examine?
What prevents them from claiming that, Your Honor, is the police's actions. If Officer Real had gone to his police superiors and further discussed with them about this criminal evidence, then it indeed would have been for his police job.
There was a famous police or school resource officer who hid behind a pillar in Florida during a school shooting, and the whole nation has vilified this guy because he didn't do his job as a police officer. What makes you think any school resource officer is not a police officer? Everybody expects you're there to help when there's trouble. You're a police officer.
Yes, Your Honor, and that would be the job of the police, of a school resource officer, but Officer Real did not participate in these duties, as evidenced
So he hid behind the pillar.
In essence, yes, in some way, Your Honor. However, it's not necessarily that Officer Real viewed these statements as testimonial for the purposes of a later trial. He was simply dealing with the emergency at hand.
But he tells the detectives about it.
Yes, Your Honor. But before that, that was only a coincidence by the officers coming to meet him at the school.
It's very convenient to say that now because he didn't need to go and seek them out because they happened to show up. But it seems a bit of a stretch to me to say that he would not have acted and done something and told somebody, afforded some indication of this up the chain.
Well, Your Honor, Officer Real, before even talking to the officers, first contacted the principal and the school counselor through the district.
He left them a voicemail.
Yes, Your Honor.
He didn't actually talk to them.
Yes, Your Honor.
Does it tell us what the voicemail said? Like, call me someday, or it's pretty weak what he reached out to do, right?
The record indicated that he was expecting a return call from those persons, but after that, he did not act for another 2 hours until Officers Cheney and Giesman came and spoke to him. However, Your Honors, even if you do find that Officer Real was acting as a police officer in this case, Respondent still prevails under the primary purpose test as identified in Davis v. Washington. Now, that test specifically states that statements given to police officers are non-testimonial when they're going to meet an ongoing emergency. They are testimonial when they're going to establish past facts for the purposes of a future prosecution.
What's the ongoing emergency?
Here, Your Honor, the ongoing emergency is Andy Somerville's mental state and response to the pornography. As an Associate Justice questioned opposing counsel, it was very likely that Andy Somerville could have gone home and further viewed further pornography. As evidenced by Andy Somerville's statement as per page 5, he
So why didn't he call his mom and do something? He just left a voicemail. If he thought that it was an emergency, he wouldn't have sat there in his office and been content with the voicemail.
Your Honor, Officer Real was waiting for messages back from these persons, and it is not necessarily stated that he sent Andy Somerville home. Obviously,
I was a lifeguard before I came into the Supreme Court. And if we had an emergency, we went and did something right then and there. We didn't call somebody and leave a voicemail. I don't see how leaving a voicemail ever is the right response for an emergency.
well, simply that Officer Real had some time before Andy was going to be sent home, and thus the emergency wouldn't necessarily take place until Andy Somerville got home, and thus he had time to figure out what to do next.
Or that it wasn't an emergency.
Or potentially that, Your Honor. And if you do find that it is not an emergency, Respondent still prevails under the expanded test as outlined in Ohio v. Clark, specifically quoting Michigan versus Bryant, in which it states that the presence of an ongoing emergency is not the cornerstone of whether a testimonial inquiry.
Don't you think that the person in Davis was still in trauma and could be exposed to more trauma? There was two halves of the 911 call. You know, he's beating me right now. Now he leaves, and now there's testimonial data gathered, right? Isn't that the fact pattern in Davis?
In Davis, during the 911 call, those statements were non-testimonial.
Well, part of them were, part of them weren't.
Yes, Your Honor.
Okay, but the emergency was the guy was there beating her actively. When he left, her trauma was there. Where's the physical danger to Andy? Not the trauma. Both of them have trauma. Where's the physical danger to Andy?
There is no direct physical danger to Andy, but under the case of Maryland versus Clark, or Maryland versus Craig, Your Honor, the court found that simply mental trauma from revisiting a sexual assault or discussing that issue was significant to override the confrontational clause in some case.
But doesn't, I mean, my trouble here though is that seems to swallow every victim, every witness to some horrific event. Everyone who's a victim or a witness to some horrific event, in this case, sex assault, you're going to have trauma. Why doesn't your line swallow the entirety of the confrontation clause in those sorts of cases?
Because, Your Honor, if Andy Somerville had gone home, he would have likely been further exposed to the pornographic materials and caused further trauma. However,
Well, how's that possible? Because nobody could find the video. In fact, under the totality of circumstances, the only evidence that there is such a pornographic video is this officer's statement that the child told him. And we don't even know if the child told him that or if he just made it up.
Your Honor, as to the record of whether there's other additional factors, as per page 7, Alfie Sasaki stated that he knew that Bobby Bronner had possessed child pornography. As to the specific video, Your Honor,
That's proof of nothing. And it's certainly not proof of that particular video.
Yes, Your Honor, and it's true that video was not found, but Andy Somerville, in his statement, states that it was like Bobby Brothers.
We don't know that. We don't know at all what Andy Somerville said. We know what the police officer said that Andy Somerville said. We have no idea, other than the police officer, what Andy Somerville said, right?
Yes, Your Honor.
The court didn't get to examine him. Nobody knows, except this police officer. He made up a story, perhaps, about there being a video.
Yes, Your Honor, and that's why Officer Real was cross-examined on the stand to determine whether he was being truthful in his recounting of these statements. However, Your Honor, even if you do not find that this was an emergency, under the precedent of Michigan v. Bryant, in which there's a middle ground between statements being not going for an emergency and not establishing a past event. There's an area in between this, Your Honor, and Respondent would contend that if it's not an emergency, at the very least, these statements were not going to establish past events for the purposes of a future prosecution, but rather that this was a conversation with his counselor. And therefore, based on the aforementioned factors, Respondent respectfully requests that you uphold the holding of the lower court. Thank you, Your Honor.
Thank you, counsel. take the case under submission and decide it faster than the U.S. Supreme Court. Oh, rebuttal, I'm sorry. Thank you. Rookie error.
Mr. Chief Justice, and may it please the court. Under the Fourth Amendment issue, the test that the respondent contends this court adopt is constitutionally problematic and unworkable for officers of the law for two reasons. First, because it creates a distinction between past CSLI data and real-time CSLI data, which allows officers of the law to simply just acquire perpetually the real-time data of individuals, store that data somewhere, and then use it for future.
What about the argument that all they're getting is phone numbers and phone numbers are not protected?
Your Honor, according to page 4, paragraph 1 of the record, that is not all that they're getting. They're also getting the CSLI data of Mr. Bock.
But did they use anything other than the phone numbers?
Yes, Your Honor, they used the location information given by cell sites.
For what purpose? How did they use it?
Your Honor, that goes to the second reason why it's constitutionally problematic. For the purpose was, first of all, it's not mentioned in the record what the purpose was to gather this information. But secondly, we contend that this court should not look at the purpose for the search, but what the search actually entails. That would be a results-based test that is constitutionally problematic and unworkable for officers of the law, because now they must subjectively determine.
But in this case, the search did not produce actual location data of this individual is standing on this block or this individual has entered into this storefront. The data that was obtained was whether or not he had crossed into a comparatively large geographic area, in addition to any phone numbers that he interacted with while he was in there. Seems like a very different privacy interest than what Carpenter focused on.
Your Honor, you are referencing page 4, paragraph 1 of the record, and we would contend that specific language is rather ambiguous on the preciseness of the location, and whether or not it's a specific location or whether or not he's just within a general area.
Do you believe it makes a difference?
No, Your Honor, we would contend that it does not.
Did the search yield any evidence that was introduced in court?
Yes, Your Honor.
What was introduced?
Your Honor, the burner phones, the 8 burner phones that were gathered through this information were the basis for subsequent searches based upon other warrants, and also the testimony of 10 individuals in trial of these human trafficking charges. But further, Your Honor, this information is constitutionally problematic because it is a results-based test and because that is very difficult for police officers to implement. But under the issue of the Sixth Amendment, the relevant facts in this case are that, according to page 5, footnote 7 of the record, Officer Real, he was acting in a police fashion. He was acting as an officer of the law. And according to Officer Real's own statements in the record on page 5, he believed that Andy knew that. I mean, in fact, on the day before his statements were taken, Officer Real was in his full uniform. But secondly, no emergency has existed. This court has never held that some abstract emotional interest is sufficient to demonstrate that emergency exists for the purpose of testimonial hearsay. For that reason, we ask this court to overturn the ruling of the lower court.
Thank you, counsel. Now we'll take it under